All right, welcome back to the Sandler Law Podcast. My name is Theodore, or Tuvia Sandler, managing partner of Sandler Law, a civil litigation firm in Miami. I'm joined today again by Dan Gielchinksy. Uh, Go ahead, Dan.
W, thank you for having me again on the podcast. My name is Dan Gielchinksy. I'm the founding partner of DGIM Law in Aventura. We do commercial litigation, corporate bankruptcy, trust and estates, and a variety of other uh, business-oriented practice areas. But we definitely stay very much involved in the corporate bankruptcy world.
All right, cool. And I like having Dan on to talk about bankruptcy issues. One of the issues that I've been tracking, kind of following more out of curiosity than anything, is the Saks bankruptcy. It's been in the headlines recently. They filed back, I think the date was January 14, and they filed in the Southern District of Texas. So I did a segment a week or two ago, putting forth an argument that they have no basis to be in Houston. I talked to Dan about it, and he, at least my understanding, is in agreement. And so I'll just kind of run through it quick. For a company to establish venue in a district, they have to demonstrate domicile, which usually means that they've been formed in that district, principal place of business, which headquartered basically in that district, or principal assets. In the Saks bankruptcy, there are only four entities that are based in Texas. All of them are domiciled in the Northern District. In other words, their office is in Dallas, not in Houston. They don't, their principal headquarters are in New York. Everything's based in New York. And as far as I can tell, they don't really have hard assets that they can claim are in Houston. So I seriously questioned whether they were allowed to get into Houston. And, once the Texas entities are out, then all the other entities, it's a total of 113 entities, all of them would be out. So, Dan, I sent you kind of what I had on this. It sounded like you agreed. Any thoughts about that argument?
I agree with you. It's like a tree falling in the woods with nobody around to hear it. Who's going to make the argument? Everyone who's there are presumably lawyers who make their living practicing in that court in Texas. And, don't get me wrong, the Southern District of Texas is known to have some fine, very well equipped bankruptcy judges to handle large scale cases like this. But the law doesn't tie venue to the ability of the judges in the district. There's specific things that need to be met to meet the venue provisions of the bankruptcy code, and I don't think any of those were met. I think big picture, and I'm just speculating here, I'm not involved in the case, but I've been involved in other retail cases and many other bankruptcies where you're talking about venue as a strategy or considering venue as a strategy. It seems to me that the reason the case was filed in the Southern District of Texas was there's probably a lot of unsecured trade creditors in the Northeast, specifically in New York and the New York metro area. And if I'm representing Saks, my bet is going to be that if I file in New Jersey or I file in Delaware or I file in the Southern District of New York, we're going to hear from those creditors and they're going to make a lot of noise in the case. But if I file in Texas, there's a significant chance that many of those unsecured trade creditors or even landlords won't necessarily make the effort of hiring Texas counsel to show up in the Texas bankruptcy proceedings. Ironically, in Texas, we're allowed to be admitted pro hoc vice. I don't
Yeah.
think a lot of lawyers know that, but I've been admitted in the Southern District of Texas pro hoc vice without local counsel. You certainly take your risk if you don't have local counsel to sort of guide you on how the judge operates. But there's judges in Texas who I feel comfortable in front of because I've been in front of them before. So you don't necessarily need to have Texas counsel. Sometimes you're well advised to have Texas counsel. But my guess is they filed in Texas on the hopes that most trade creditors who are bound to make noise will not make that same level of noise or any noise at all if the case is filed in Texas because they won't go through the trouble of getting a lawyer in Texas.
Yeah, and just to kind of echo that, I'm generally on board. It's my sense, this is not unique by any means that a company files in a seemingly completely random district. Delaware arguably could be said some of the biggest bankruptcies in the U.S. go in Delaware. I mean, no big corporations are headquartered there, and they still file there. It's been happening a lot in the Southern District of Texas. So there are various reasons it may happen, but I do think that one of the primary drivers is to escape the creditors. And like you said, it is true in the Southern District of Texas, you can be admitted without local counsel. So as long as you're an attorney in one jurisdiction somewhere in the U.S., you can get into Houston, but it's still not the same. I mean, nobody's on the grounds. The first day hearing where hundreds of millions of dollars were approved in funding and critical vendors. It was conducted virtually, as well as the final hearing on the first day motions. It's going to be conducted virtually. Um, and I think all lawyers know that a virtual hearing is just not as effective. If you want to really kind of attack a witness or cross-examine a witness, in person is much more, you can feel it much
Right.
more than virtual. So just the mere fact that everything turns into virtual and everything's kind of remote, I do think it kind of puts a damper on the case as far as being able to really come in and make some noise from a creditor perspective. And just what you said, that a lot of the creditors are in New York. I'm just going to quick share my screen here. So last night, the United States trustee filed the appointment of committee of unsecured creditors. And in every case, or well, most cases, there's a committee of unsecured creditors that represents the body of the unsecured creditors. So you can see here who's listed. They're almost all in New York or Washington, Chicago, and California. Amazon, they're a big one. They were at the first day hearing objecting. It was actually interesting to me that they're on the committee. They have, we'll talk about them, but they have a very large claim, and they were claiming an interest in their building, the Saks building up in New
Right.
York.
Right.
It's interesting that they went on the committee because, well, we'll talk about it. But as you can see here, almost everybody's in New York. So, you know, like you said, I do think
Shaking
it.
off those creditors.
Yeah, I mean, it's strategic.
Yeah.
Amazon alone. So, Amazon had a big claim in the building, and my sense of it was that Amazon wanted the building out of the bankruptcy. You could kind of see that. Amazon's trying to get into luxury retail. They probably need a nice warehouse in Manhattan. I
Right.
thought there was their angle, but I mean, being on the committee, they owe fiduciary duties to the estate. It's going to be hard, I think, for them to really try to carve themselves out. What do you think about that,
I
Amazon?
think Amazon's interests here are different than your typical creditor. Amazon's got equity in this deal. Amazon put a lot of the funding into what became the Neiman Marcus transaction, and now Amazon's arguing that putting the real estate into the collateral pool for the DIP loan essentially wipes out their equity. And they may be right. We'll see how the court ultimately rules on that, but the court did provisionally approve a portion of that DIP facility. So I think Amazon's going to have a little bit of an uphill battle on that issue. But Amazon is unique in terms of the creditor body as a whole. They're certainly not a trade creditor. They've got a lot of money in the deal. So it'll be interesting to see how Amazon navigates their fiduciary duties to creditors while maintaining the position that they're going to take in respect of their equity claim.
Yeah. Yeah, I agree with that. Yeah, it'll be interesting to see how all that plays out. And maybe that's an indication that they're kind of backing off. I don't know. We'll see how the case develops.
I don't expect Amazon to back off based on what I read and based on the arguments that were presented on those first days. I don't expect them to back off. I expect them to be the point of contention in this case. And I suspect that they were glad to take the committee seat to try to get more support for their position and rally more support through the committee behind their position.
Yeah. You read their objection the first to the dip,
Yeah,
and so people understand a dip is a debtor in bankruptcy can seek a loan in the bankruptcy that takes priority over other creditors. It's called DIP, which stands for debtor in possession financing. So the DIP motion, that's one of the big motions that gets filed usually on day one, and that's usually the most contentious of them. So Amazon took a hard shot at trying to stop it. They even threatened moving for an examiner, appointing a trustee, which are usually considered drastic steps in these sorts of bankruptcies. So my read of that hearing was they're after the building. I mean, but I don't see how they do it if they're on the committee simultaneously. So yeah, we'll see how this all this shakes out. It's looking kind of interesting at this point.
definitely.
Another thing I wanted to raise, and this I was just kind of blown away when I saw this. A couple days ago, the debtor filed a retention application. They're proposed so in bankruptcy, any professional that a debtor wants to hire to use in the bankruptcy and pay, it needs to get court authority to hire them and to pay them. So it's the lawyers, the bankers, financial advisors, they need to file what's called retention applications, basically disclosing their services, their billing rates, and if there are any conflicts. So the proposed counsel to the debtors in this case is Wilkie Farr. That's a big firm up in New York. So they filed a retention application a couple days ago. I'm just going to put it on the screen. So if you look at their fee rates here, these were just astronomical. I hadn't seen these numbers before. So you can see their top partners here. The top partner is billing $2,795 an hour. Going down to the associates, their lowest level associate is in excess of $1,000 an hour. Um,
Right, $1,150 an hour for an associate. Look what a law clerk is billing 925 an hour,
a law clerk means they're not even admitted to the bar.
right?
And
I
look, I'm not taking any issue per se with them billing this, but it's just, I mean, the rates, when I was doing this a few years ago, the rates were, I think everything was right around like 1,000, 1,100 for the partners. Associates were well down into the hundreds, which was still high. But now, I mean, these rates are just
They're
incredible.
astronomical,
Yeah.
and these are all very fine lawyers, and the law firm is an excellent law firm that gets great results for its clients. There's no question about that. But, I just sort of question, what are we doing to ourselves as a profession? When I got into the Chapter 11 world early in my career, and I'm talking 2001, 2002, even 2005, there were meaty Chapter 11 cases to work on. Uh, because, at the time, if you had a good company, you you had different levels of constituents. You had different shareholders, different classes of stock. You had different tranches of financing. You had your initial bank loan, and then maybe a line of credit or a letter of credit, and then another, a mezz loan, maybe. But you had a structure. As things advanced during my career, if you had a good company, you basically sold it to private equity. And sure, some hanger-ons were always there, some bondholders or some original equity holders from the first raise or second series raise were always there. But what happens now is rarely will a small to medium size operator wind up in Chapter 11, because the private equity people will get everyone together in a room and say, look, we can spend $1 million on bankruptcy professionals, or we can stay outside of bankruptcy court and do this on a streamlined basis. And we all know what the outcomes are going to be, right? I mean, there's only a certain amount of
Yeah.
outcomes. We can all sort of gauge what they're going to be. So more and more cases are staying out of Chapter 11. And now you have these rates where you're literally making it unaffordable for a company that's bankrupt, right? The company is declared bankruptcy, paying these $2,200 an hour rates. I just wonder, as a profession, are we going to make ourselves extinct with these sorts of rates and the cost of maintaining a bankruptcy? Even a small Chapter 11 these days can run about 100,000 on average, which for a struggling company is real money. Now you're talking about Sachs is going to spend how much? 100 million on this bankruptcy? 50 million? I don't even know, but
And
it's
that's just the
a ton of
lawyers. I
money.
mean,
That's
right. I
just the
mean,
lawyers.
they hired bankers, they're hiring a real estate advisor, they're all going to get paid similar rates. It's pretty amazing. But I mean, but these rates, I mean, they're almost certainly going to get approved. Rarely are these rates challenged. Which
Right.
is
Who's going
really
to challenge them? The other lawyer that's trying to make 1,800 is going to challenge the lawyers making 2,100. I mean, again, it's like a tree falling in the forest. It just gives me pause in terms of where this industry is going. But anyone who can get that rate approved and paid, God bless them.
yeah, yeah, I agree with that. All right, so one other thing I also kind of caught my eye in this case, maybe just to talk through. So one of the first motions that gets filed, and especially in these retail cases, is it's called a critical vendor motion, which is basically so a company in bankruptcy is not allowed to pay any of its creditors except through a plan, right? So there has to be disclosure around who's getting paid, et cetera. In some of these big retail bankruptcies, courts often will approve critical vendor motions, which is basically the company says, look, if I can't pay these vendors right now, then I might as well just close shop today because I can't continue operations without them. So in this case, I'll put it up on my screen. So this is the critical vendor motion. I'm kind of just skipping right to what they requested. So you can see the first day motions are heard twice. There's usually they're heard day one or day two and approved on an interim basis, and then there's a final hearing. In this case, it's going to be heard on February 13th. So the interim request, which means day one, they sought $126 million in critical vendor payments, and on a final basis, they're looking for 337 million unchanged, which also those are just huge numbers. And if you look at the order, there's really very little disclosure, at least to the full body of creditors, as to who these vendors are that are getting paid. Um, I thought that was a bit unusual, just as far as numbers go. Uh, any thoughts on that?
Yeah, it's a big number. Typically what would happen is the unpaid vendors would file a proof of claim for their what is now an unsecured claim. And if they want to do business with the debtor going forward, they'll get paid, in the ordinary course, just as someone supplying product to the debtor. But what's happened here is Saks is so far behind on payments that I suspect its vendors are telling it, unless you catch me up on what you owe me, I'm not shipping you any more product. So, one of the critical failures of Saks was that it was in this death spiral where it wasn't paying vendors, so it wasn't getting product, so customers didn't have product to buy, so they weren't coming back into Saks. So I guess one could argue that this is a step towards remedying that death spiral and allowing Saks an opportunity to catch up on payments that are overdue to the vendors that it has deemed are critical to the maintenance of its business and having the right product mix on the shelves. It's just unclear to me from the motion, like, who are those people? What Saks paying for? What are they owed? Were any negotiations had to ask those vendors to have part of their claim be, remain as an unsecured pre-petition claim, and then part of the claim paid through the critical vendors motion? Or was this just sort of a broad stroke or a blank check that was approved to just pay a whole bunch of vendors and get product into the doors? It's just not the level of disclosure I was sort of hoping to see in this type of motion, but it's been improved on an interim basis, and I guess if Saks gets product in the doors, that's a good thing. So we'll see.
Yeah, it's interesting. I mean, they now have a committee in place, so I think, I mean, usually these vendors get disclosed to the committee, so at least there'll be some eyes on it. But I mean, that is a big number. I read up on this back in the day, like decades ago, before critical vendors. The whole notion of critical vendors didn't really exist. It really
Right,
came about in the 80s, 90s. And the way debtors used to deal with this is saying, look, you need to continue trading with us. And if you don't, we're going to seek to hold you in contempt of the stay because you're demanding payment for past due debts, which you're not allowed to do. And
right,
so there was a way that it used to be done, but slowly this notion of critical vendors developed where some vendors basically are preferred over others. So, these days it's pretty routine, but it's really kind of luck of the draw. The important creditors are going to get paid now ahead of others. Um, and it's just kind of the way the things work these days.
it's just a big number. Even for a big case, 126 million on an interim basis is a big number. I was looking at a small case the other day where the critical vendor that was being paid was $8,000.
Right.
Okay, and there was disclosure around who that critical vendor was, why that vendor needed to get paid, and what sort of product that vendor was anticipated to continue supplying. You don't really have that level of disclosure in this motion, considering that it's such a big number. A little surprising to see. I can imagine that the debtor didn't want to step on the toes of those vendors who are not receiving that money, or perhaps there's some thinking that, get it approved and we'll decide later who's going to get which money. But
Yeah.
that's not really the way it's supposed to go.
Yeah. All right. So we'll see how the case develops. Maybe the committee comes in and pushes for a little more controls around all this. But shaping up to be an interesting case. That's what I wanted to talk about. Anything else you wanted to bring up?
Well, we've got this off fifth digital liquidation that's going to happen. That was just approved, I believe, yesterday or 2 days ago. So I didn't expect that to happen that quickly, frankly. The off fifth digital, the online off fifth business gets a lot of competition from like the Ross Dress for Less and the other discount type stores. Um, I was of the impression that that platform also had a very robust online retailer platform, and that platform, notwithstanding the products, the actual, handbags and dresses, but the actual software and systems platform would be retained throughout the case, and that the other retail affiliates would eventually operate through that platform. But it doesn't seem to be going in that direction. It looks like everything that Saks Off Fifth Digital is going to be liquidated. So
Mm.
now's the time. Get online if you're into that kind of stuff. Go to the Saks Off Fifth
Yeah.
website, and
Uh,
from what I understand, there's deals to be had. The only issue is once you buy it, that's it. There's nowhere to
yeah,
return
yeah.
to.
No returns. Yeah. Yeah, actually, interesting. I hadn't really followed that piece of the case. So it looks like there's an interim order allowing, I guess it's a continued liquidation sale or something like that. And then the final hearing is February 13th. And then that's almost for sure going to get approved. So
Yeah,
it'll be done
but
and go out
by
of business,
February
basically.
13th, it'll be sold and done.
Yeah. Interesting.
Yeah.
All right. Uh, very cool. Thanks for taking the time. If you
Thank
want
you
to
as
check
always for
out,
having me.
where can people check out your firm?
www.dgimlaw.com or on social media. We're on Facebook, LinkedIn, and Instagram, DGIM.
All right. And to check out my firm, sandlerlawpa.com. I'm on YouTube at Sandler_law. Thank you for listening. If you liked the episode, please like and subscribe. All right. Talk to you later.
Thank you.